Welcome everyone. If you haven't joined before, my name's Jason, and the only other guy on the screen is Daniel. We've been running these webinars for like a year and a bit now,
Yeah,
Daniel.
COVID webinars.
COVID webinars, and we're really excited to do this one, Introduction to Contract Reviews, especially since this is, I guess, a topic that's near and dear to my heart, at least, having gone through the gauntlet of having to do, strings of contract reviews through my career, starting from having absolutely no idea what I was doing, to now being a lot more comfortable with them, at least. So I guess just as way of background, again, if you haven't been to these webinars, Daniel and I are not sponsored by anyone, which means we can keep our chats really casual. We can give our honest views based on our experiences, and actually give you guys an opportunity to perhaps ask questions that you wouldn't be comfortable maybe asking to people you actually work with, or that sort of thing. And I guess the structure of these sorts of presentations is we'll do some talking, but you feel free to pop questions into the chat as you kind of have them in your head. Hopefully we have enough time at the end to go through them. And as always, we'll be sending around the recording and the notes afterwards as well. So I guess, Daniel, do you want to tell them a bit about yourself?
Yeah, happy to. And guys, if you feel comfortable, we would love to see your faces because we say this every time, but it gets a little lonely when we're just me staring at Jason, Jason staring at me, although he is a good-looking guy. So yeah, feel free to turn on your cams. But yeah, my name is Daniel. For those that have not been to these things before, I am currently an asset management lawyer at UBS, not sponsored, just to be clear. And agree with Jason about contract review. These are things that you kind of cut your teeth with when you're doing your training contract early on in your career. For me, it's less so contract review, but more due diligence, which is our next seminar coming up in the new year. So I'll be leading that one. Jason will be leading this one as he is primarily commercial focused and has a lot more insight on this than I do. In my current role, I just kind of outsource it to external counsel. So not the best person to speak to about this, but I will chime in here and there.
Sweet. And my name's Jason. I'm a construction lawyer at Pinsent Masons. Look, for the last 2 years, two and a bit, I've been doing how-to guides and resources for junior lawyers, and this is a part of that, more interactive, a bit more face-to-face, actually get to see you guys in person. And really, I think the goal of this session is to cover a few things. So number one, understanding the role that contract reviews play in modern businesses. Number two, the features of what a good contract review actually looks like. Three, the things that you should consider and ask before you even open the contract. And number four, a step-by-step approach on what to do when you're reading through the contract. And I guess to contextualize this, look, the first few days that I went into a law firm, they said, hey, here's a contract, can you review it? And, coming out of law school, I don't think I even read a contract in full in law school. And it was kind of like, well, offer, consideration, acceptance. Yes, this is a contract. I have reviewed it. It's like, well, no, let's read through it. What are the key risks? What are you actually doing? And starting from that sort of knowledge, I've tried to develop a bit of a system to actually teach other people, teach junior lawyers how to, I guess, approach the whole process from start to finish without just saying general things like, hey, identify the key risks. So I guess on that basis, we'll start with the first bit, understanding the role of contract reviews. And I think in general, the contract review is really to identify and summarize how the contract works. But as part of that, yes, you are flagging key risks, but you're also making sure that the contract processes are really workable. So for example, there might be notices clauses, there might be time bars, there might be things that say, hey, whenever this happens, within 1 day, you need to submit a notice. And if that notice has to contain, a whole bunch of reports and things like that, then that's not workable. So we need to make sure that the contract works as well. And as part of that, we'll check the commercial terms and make sure that the timeframes and the deliverables are correct as well. So what the business uses contracts for, and now that I'm kind of exposed to it and guess Daniel's kind of living it. I've done it through secondments, but I've seen businesses use contract reviews that we produce for all sorts of things. They'll be negotiating and pricing new contracts that they're bidding for. They'll use lawyers to help them turn their minds to questions from the contract that might not have come out of the commercial negotiations. They'll make sure that there's appropriate insurance coverage to cover off the key risks that can't be priced or managed. They'll be using it to actually brief their supervisors, their executives, the directors to actually say, hey, look, this contract has appropriate risks that we can take on, or we're going to compensate for the risk that we are going to take on in this contract. They'll use it to actually get approval to enter into the contract by getting the directors to sign off and say, hey, look, that's fine. We can accept these risks because we're getting compensated for them. And on the later end of things, they might actually bring us in after they've already signed a contract, done it for a few years, found out it wasn't working, and use the review as a basis to renegotiate or decide whether to terminate the existing, unprofitable or unworkable contracts. And I guess if you look at the screen right now, that's an example that we pulled from the web, so we don't, breach anything. But it's essentially an example of what a business has as their contract review framework in terms of saying, hey, when we reach these level of risks, we will actually need lawyers to come in and review the contract. So I think a lot of it is, hey, look, the contract value, if it's below a certain amount, yes, that's fine. The commercial can do it themselves. They don't need to involve legal. But as the contract value goes up, then it's better and it's actually worth it to bring on lawyers to review it in full and advise on all the risks. But again, the contract value is not the only factor, obviously. So, if you've got a $100,000 contract, which might be below the monetary threshold for a review, but there's, risk to lives, there's risk to business, there's, I guess so many risks that could lead to the insolvency of your actual company, then that's another way that you actually bring in lawyers and say, hey, look, when it's not worth that much, but there are some key risks that we need to think about. So hopefully that gives you a bit of, in a nutshell, what a contract review is used for in businesses and how, the people in business that are clients for private practice actually view the final deliverable and use it once they receive it.
Jason, I might add, there's one
Yes.
thing that those are all exactly why in-house would actually engage external counsel for contract review. One thing that we see often in in-house now is where you have a global business and you have contracts that are maybe domiciled in the UK or Australia, and you're moving, or it involves another international entity, and the governing law is Seychelles or somewhere else. Often you engage external counsel to make sure that it adheres to all relevant local laws. So it's a very wide gamut, that kind of scope. And we often get that our Luxembourg funds comes to Singapore and says, hey, can you review based on Singapore law? That's very broad. So when we send our contracts over to Singapore Council, they need to go through the process of saying, okay, well, are these provisions the same way? Is negligence treated the same way here versus in Cayman Island? That kind of comparison is another kind of contract review that external counsel provides as well.
Yeah, and that's a really good point. And I guess for the purpose of this presentation, we're trying to make it as general as possible. So it covers, all sorts of different practice groups. But again, the contract review actually looks different depending on which practice groups you're in, what level of detail the client needs, what sort of matters you're facing. I've seen things as simple as saying, hey, I'm going to flick you some documents because this is going to be governed by the law of, like you said, the Seychelles or wherever, and we don't know what that's going to look like, but we just need to make sure that it's not illegal there. That the directors are actually able to sign off on it, that it is, enforceable against the company if they do sign this sort of contract with that sort of governing law. And because of the range of the forms that the contract reviews can come in, you can see things as simple as, a few dot points in an email saying, hey, look, these are the main issues that you've asked us to review, so here they are, to something way more comprehensive, which is, complete tables of issues and proposed changes, key risks, things to consider, questions for commercial, things like that. And in other cases, really simple could just be comments in the document if they're trying to limit legal spend and that's all they need. so I guess on that note, it might actually be good to go over what sort of stages or features a good contract review would have. And I've tried to break this down in terms of how I actually learned it and how I actually developed my skills in doing contract reviews, because I think at the basic level, so at the very basic level, we're all good at summarizing what's in the contract, right? So that's an example, but really, if you come into the contract and they say, hey, can you look out for this risk and tell me what the contract says about it? I think we can all do that. We've all done various comprehension level tests throughout, primary school, high school, blah, blah, blah. That's what we're good at. So, it's really easy to say, hey, by the way, clause 10 states that the contractor will be entitled to additional cost plus 5% margin for variations. Okay, we can all do that. The next level, which is harder and comes with experience, is identifying what's not in the contract, if there's anything, right? And if there's anything missing. So in this example, as you develop your skills and actually learn what's normal and what's not for your particular practice groups, you can say something like, hey, however, there is no express provision for margin if the principal omits work from the scope. Okay, so that's the next level. What's the third level? Third level is linking it to the practical implications and your client's particular situation. So now it's not just saying, hey, I know what's missing from the contract, the standard contract. I can also link it to how this will practically affect my client. What I know about my client that's unusual, that may be different from the generic client. So you can say something like, we understand it's not uncommon for projects of this nature, and your previous projects that you've had, because we've worked with you, to involve omitted scope. Okay, we know your previous history as the client, as your counsel, and we want to build on that. We want to build on that experience as well. The next level is knowing what the market standards are. So again, that can take years. That changes over time. I don't expect anyone, first year coming in to say, hey, according to the market, this is my experience. But once you reach that level, it's helpful to use that as a guiding point. So in our experience, requesting an entitlement to margin for works omitted by the principal is common in market standard contracts for projects of this size. Beautiful sentence, takes time to develop that sort of skill. And then finally, and I think this is the most important thing and really, really key for junior lawyers to start getting their mindsets into, is actually providing the recommendation. Because it's not enough to just tell them, hey, this is nice, this is not nice, this is a risk, this is not a risk. You need to provide, as a counselor, as a consultant, someone that they're engaging for advice, will actually provide them advice, provide them a recommendation, saying something like, based on the above and your lump sum pricing model, we suggest a departure in relation to a margin if the principal removes work from your scope. If you agree, please let us know the percentage amount. Really spoon feed it as much as possible if you can, saying, look, this is the issue, this is what we think you should do. If you want to pursue this, we need this to put into the contract. Really spell it out for them, make it as easy as possible for them to say, hey, that's great. Or, we like that you thought about it, but we're going in a different direction because XYZ. So as long as you're kind of getting the gears turning, you're adding, intellectual value. You're not just being that thing that can be replaced by AI a few years down the track, where it's saying, hey, we'll just scan the document and tell you what is there, what isn't there. And chip in whatever you want, Daniel, but that's kind of the framework that I've personally developed for how I want to approach contract reviews. And again, it varies on experience. Sometimes you might not know these answers, but if you can kind of work through these process and you can kind of know the layers that you're trying to work towards, then that's a really good starting point for developing these skills in future.
Yeah, I would add that I think that this exact skeleton is what you would expect from counsel to provide you with advice. A value add, I think later on, depending on your client, of course, is whereby you not just look for the holes in the agreement or any kind of risk, but highlighting good provisions that you got out of this. If you got an indemnity from the contracting party and this is rarely given and they gave it to you, it's good to highlight this to the client to let them know that, hey, over here you actually benefited a lot here. Just to say that maybe later on with other contracting parties with similar agreements, you can look out for this. You can maybe insist on this because you got this before. That's just an additional thing you can provide to your client, so it's not just all kind of risk holes and whatnot. So that's
Yeah,
what we're seeing in our business as well.
Yeah, and I think that's an awesome point because I think with lawyers, there's a tendency to just advise on the red flags, the issues that the contract has, and we don't go as much into the opportunities, which if you think about it, are actually really important because okay, if there's some issues with the contract, but you're getting way more, better commercial terms than you thought about, then that those problem areas might not be a real problem, so it's important to kind of step out as well and say, okay, as a whole, yes, there are some issues with the contract, but we'd also like to highlight some of the opportunities that this contract has, which may make it a lot more palatable. So I think that's a really good thing to kind of watch out for as well, not just isolating the risks. Or I guess, not just isolating the negative risks, it's the positive risk side is important as well. Cool. So we might move on to things to do before opening the contract as well. And I think, when I started, I was kind of tempted to just dive into reading the contract, showing that I could, do the legal part, really show I knew what the contract says as soon as possible. But I think, now that I've worked in it a few years, I think there's an important preliminary step that I didn't quite appreciate as much, which is, what do we do when we receive a contract and before we actually flip it and just dive into the technical exercise. I think the first part is really trying to understand your client and your project. So there's a few questions that you'll try to ask or try to get information for before you dive right in. So number one, very important, who are you acting for? Not just in terms of the entity, right? Like, yes, here's your name client, that's great. But, in my line of work, it's important to know, for instance, if they're the principal or the contractor or a subcontractor, because those things essentially flip the risk profile, right? If I have a contract that's really, it could be really good for a principal, but if I'm acting for the contractor, then that's the worst possible contract that they could have. So understanding where your client kind of sits and also where they fit in the contracting chain. So again, if there's principals, contractors, subcontractors, those sorts of things, whatever your practice group area kind of deals with on a day-to-day basis, it's helpful to know where they fit in terms of the web of contracts. So I recently came off a roads deal where when I tried to draw out all the contractual relationships and all the parties, it was literally like looking at a spider web. But that's kind of what I needed to put onto the paper to understand, hey, this risk on a contract, it affects our client, or this risk does not affect our client, or it's really important to have this in there because of where we sit. So, it can be helpful to actually prepare that contract map to understand where your clients fit and understand where the commercial pressures come from.
I
Um,
would also add, Jason, that's
mm,
fantastic point about knowing who you're acting for, especially if you, once again, if you're in-house and you're working for a conglomerate or a big company with different affiliates, different
mm,
uh, group entities, often not then where they define the contracting party, it's party A and their affiliates or their group companies. And then you need to figure out, okay, well, am I representing these companies as well? What interests are there for them? Also, any special advisors we need to concern about. So it's not just contracting A and contracting B, it's also whatever's linked within that agreement. So it's really, as Jason said, really important to kind of lay that out right at the outset.
yeah, and I don't mean to like unnecessarily make this more complicated than it seems to be, right? Like sometimes you'll just get a straight contract where it's just two parties and it's great. But for example, I could get a contract that's between a principal and a contractor, and I could be acting for the contractor, but then I also know that they're going to enter into multiple contracts underneath that. So all of those terms need to be commercial enough to actually pass down in the chain later on as well. It's not just enough to say, hey, we entered into a great contract for those two parties, because you're going to essentially have to replicate the risk for all the downstream parties later on as well. So that's a bit practice group specific, but that's the sort of thing that I would need to look out for as well. And I guess the other point is really understanding how your clients make their money. So I think one of the key examples that made me note this is I had a client that was in the demolition context, they would do demolition work, and that was all great, but they actually made a fair amount of their revenue through actually salvaging the material as well and selling it off to other companies or recycling plants or things like that. And that was unusual for those particular demolition contractors. So because of we knew that that was how they made their money, we made a special point to negotiate rights to salvage materials into all of the contracts that we reviewed for them. Highlighting, hey, by the way, this says you can't salvage materials, or it's silent on it, or we need to put something in there for this. So that's an example of why it's really important to actually know where they make their money from. And then I think finally, just knowing what's involved in the project itself or the matter itself. Are there any particular risks or opportunities on the commercial side to take a look at? So again, using a demolition example, there's standard insurances that are put into a lot of construction contracts, right? And if you pull a stock standard construction contract and try to use it for a demolition project, there's a bunch of insurances in there that are only relevant to if you're actually building something, not if you're demolishing something. So just knowing what type of work that your client's doing, what sort of projects they're doing, what sort of matters they're getting involved in can help you keep an eye out for those things that shouldn't be in the contract or should be in the contract. That, look, let's be honest, a lot of us lawyers as an industry, we pull things from previous projects. We try to reuse material and IP as much as possible. And as part of that, things can be missed when you're trying to make it a lot more project specific. And I guess if we kind of nail those points, the other thing that you might receive as well before you even open the contract is a standard contract review guideline. So I put an example there on board. You don't really need to refer to it, but I think the point is, look, there are documents that the clients produce, especially big corporations like Daniel's, like wherever. They obviously review a lot of contracts, enter into a lot of contracts. So they've kind of developed a bit of a playbook or guideline in terms of, hey, we need this sort of risk profile, or we can only accept things that are within this range of risks. And these could be things like indemnities, limitations of liability, consequential loss exclusions, the right to additional time or costs, particular requirements to comply with laws, or particular areas that the client has been burned in before. They might put it on paper and say, look, we are not going to accept anything above this level of risk again. And if our contracts have something that's above this level of risk, then this might be an acceptable compromise position that we can offer. These are the common issues that we face. These are the things that we might say, hey, can we negotiate on this? So it's also worth it to ask if your client has one of these guidelines already made, instead of blindly saying, hey, I'm going to review this contract in isolation without referring to something, because they'll tell you later, but by then you'll be doubling up on the work that you could have saved yourself if you just knew it from the beginning. Is that something that you've got, Daniel, a bit of a playbook on contract reviews or DD?
Yeah, definitely. All our external counsels, we have a DD, even for a simple agreement like an NDA. There's certain guidelines that we, exactly as Jason's saying, indemnities, limitation of liability, that we've been burned before. But also the playbook always changes too, based on external counsel's advice. If it's not marketed anymore, they'll advise it. But I think within big organizations, there's standing operating procedures, very structured.
Yeah, and I think that there's varying levels of how up to date they keep these, but for the bigger organizations, they're very up to date. I think we've been dealing with things like, hey, we need to watch out for bushfire risk or COVID risk or this thing, that thing, whatever. The things that have recently been popping up, they've already updated it for. So it's good to at least ask if there is one and kind of refer to it as you do your contract review. And I guess since we've kind of put it on the slide, we won't run into it in detail, but you can kind of see how it's structured, right? There's an item, hey, in this case, it's liability caps. There's a risk issue. We say, look, the contract must provide this, the cap on liability must be this amount. Limitation clauses need to be stated to survive termination. So that's kind of the position that we'd expect. And then And on the comment side, uncapped liability must not be accepted, annual payment must blah, blah, blah. Kind of providing a recommendation of what to do, or saying, hey, if there is uncapped liability, we're not going to accept it. So provides a recommendation for it if the contract has it. Like, let's say, look, this is what acceptable. So saying something like, we have uncapped liability in this contract, but we know that you usually accept, 50% of their first year's annual payment. So that's what we suggest negotiating with the client, with the counterparty. Yeah. So, just before jumping on this as well, I guess just again having an understanding of the form of contract review, and not so much in terms of, like I mentioned, the email list or the full blown whatever it is, but before you're opening the contract, it might also be worth knowing, hey, is there a template form that the client has for their internal approval processes? Because yeah, you're usually going to be talking to legal counsel, but they're ultimately going to need their director to sign off it, or they're going to need to talk to the commercial team, the work winning team, and say, hey, these are the risks and let's work you through it. And they usually have templates for that sort of thing. So it's just helpful if you can say, hey, we'll feed our contract review through your your approval process template, your whatever form you got. So they're not doubling up on work and you're not doubling up on work. And then the other part of that formal contract review is saying, hey, is there a comprehensive, is this going to be a comprehensive contract review? Do you want us to read it from start to finish and flag every sort of risk and opportunity that we think is material for your business? Or is it more of like a concise red flag review where you only want us to look through the contract and advise you on certain risks that you've already identified? Because that is important to, in-house counsel managing budgets and how much time the external legal counsel is spending on things, and ultimately you're spending on things as well. So knowing that upfront just kind of dodges the awkward, I guess, miscommunication that might occur if, Daniel wanted a really short, hey, here are 5 risks I want you to comment on, and I give him a, I've spent half a month on this and I'm going to bill you half a month on this because your contract had all of these things that are also wrong with it. So yeah, that's also just, from experience, something that's kind of important to flag early on. Daniel, did you have anything else to chip in on this?
Nope.
Sweet, easy. So I think with that, we'll jump into the actual meaty part of this, which is how do we approach the contract review? And look, I've been through these sorts of sessions from a variety of avenues. What I've had an issue with in terms of learning how to approach a contract review is they're really high level. They kind of just say, look for these things, don't look for these things, write it out like this. But what I was at least looking for was something a bit more detailed in terms of, okay, look, on the first read through of the contract, what should I keep a note out for? How should I approach it? What should I do? And then when I read back through it, what should I be doing after that? So I guess, my approach is the first time you look through a contract, the things that I would keep a note of is there's an index to most contracts, and that'll give you a good snapshot of the structure and the issues in the contract itself. There's the definitions that I would skim through just to get a feel for the flavor of the contract, what sort of involvements, things are. They usually have kind of technical terms in it as well, so you can keep an eye out for it when you're reading through. So it's just good to give the definitions a bit of a skim as well. And then finding out what are the contract documents, because I think anyone who kind of picked up a contract knows that it's sometimes not just self-contained in the one document. Sometimes it'll say, hey, this is the contract, but also X, Y, Z, all these other documents that we're going to attach to it and may not be available yet. So, they may be split up into multiple documents, may be supplemented by other documents, might be letters of intent, might be amendment deeds, things like that. It's just good an idea to know, hey, what am I actually looking at? What is the contract? And then as part of that, it's also good to know what the order of precedence is for those contract documents, because, I've reviewed contracts where sometimes the commercial scope actually supersedes the terms of the contract, which the lawyers meticulously drafted, and oh, on top of that, there's what the commercial kind of put together. So it's just good to know, what the documents are and where they sit relative to each other. Then we move on to the main body of the contract, and that's usually the bulk of the legal terms that we're concerned with reviewing. So we'll get into that. But then again, there's the schedules, and for me, I guess, my practice group, there's the scope. And I don't think you should underestimate it. Usually they don't get us to review it in detail, but there's many times when there's schedules that commercial team would have prepared, or they came from somewhere, and they're just meant to be saying, hey, put brick X in this area. But other times they actually contain legal terms, or even worse, attempts at legal terms that cut across the main body of the document that you're going to be reviewing. So when I read through that, I kind of keep an eye out for those sorts of things. And what do I actually do for the review? Well, I think for this first read through, if we refer back to that 5-step sort of layers of a good contract review, that first read through is really helpful for the first two stages, which is number 1, summarizing what's in the contract, and number 2, identifying what's not in the contract. And look, I think depending on how you've kind of worked in the past, there's no real set style to this. You can do things like comment bubbles or notes throughout the contract, or you can write it out in a list in a separate document, kind of stream of consciousness. That's how I approach it, just saying, this looks like an issue, this doesn't look like an issue, this ticks off a commercial risk, this seems to be a blank spot in the document that someone needs to, fill in. So, as an example on the slide, those are the sorts of notes that I'd be making in the contract, right? Look, this clause is inconsistent with the contract guideline because this. There's an indemnity for data security. It seems to be onerous. Let's double check it. Or I won't run through all of it, but that's kind of the way that I would approach it. Really stream of consciousness, just kind of flagging things as I go, that I'll refer back to later, that I'll cull for the second read through. So those are the sorts of things, but to give you a bit more of a flavor, look, the things to keep note of: party entities and execution blocks. Are they correct? Blank areas in the contract. So there might be commercial terms, they might not have been filled in, but again, can be really important. So let's flag those maybe at a list in the end. Commercial terms to be confirmed. In my line of work, there's mathematical formulas, references to indexes, all sorts of things that I don't have the expertise to actually make a call on, but sometimes the clients will need to have that flag to them saying, look, in whatever area of the contract, there's this thing that's buried. Can you just check whether that's correct? And then also if there's any missing definitions, or there's an existing definition that's never referred to or looks a bit weird, those are things that you kind of flag as well. So I guess, like I said, that's an example of how I would produce something. So obviously it'll be a lot longer depending on the contract, but it's a running list. It's something that I can refer to and kind of flag and refresh my memory when I read through it a second time. And then from that sort of list, I'd try to also set out some questions for the client. So like I said, if there's commercial terms to be confirmed, yes, let's check it. But there's other questions where it might be, hey, are you willing to take on these risks for whatever things, or are you going to be able to price this risk or manage it practically? Those are some of the questions that I might want to flag for the client as I'm going through. And then there's also, the areas that are different to the client's commercial risk requirements or what I think is market. And I think if you do have something that's like the client commercial risk guidelines that we referred to before, if you do have that, then it's also helpful to check out that, check off the areas that do comply and should be acceptable, because they're going to need to kind of flag that with their internal review process as well. Just saying, hey, look, there is a limitation of liability, there is blah, blah, blah. So having that sort of checklist. And then also for the first read through, I'd like to flag any areas that require further research or deep dives into the documents sometimes. So I think a particular example would be, I had a project which said, look, we need to comply with everything as part of the Critical Infrastructure Whatever Act. And that's not something that, I read for fun or have knowledge of in my head. But that might be and that might be something that the client is used to complying with and knows exactly what to do. But on the other hand, that might be something that is new to them as well, and will need us to, follow up with some supplementary advice saying, hey, these are the impacts, blah, 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 which will, take a lot more time, take a bit more effort, and ultimately might not be in the scope of what they expected us to find in the contract. So I think that's also something that I try to flag in the first read through. Um, Anything else that you would do, Daniel?
Yeah, I mean, I think on your points about more things to note, I would on my first read through, I would always be over inclusive versus under inclusive because you can always cut down your comments. So say for instance, also I would never assume. So if say party entities execution blocks, there's one execution block. If you're dealing with corporate, they may have internal guidelines saying that it must be signed by two people, witnessed, or it must be executed as a deed. These things you don't know if you kind of just take it at face value. So I'd always highlight it to say client to confirm that one execution block is fine, or does it need to be executed in a different way? Um, Commercial terms as well. I would always flag just to make sure this is the price that you want, this is the percentage that you want. Please confirm. Once again, I just try not to assume because been burned before, where assumed entity name is even correct. Even when an entity name is typed all in caps, that's wrong. It's not registered all in caps. So little things like this is good to note, and I think it's just good attention to detail.
Yeah, and I think you'll kind of develop examples in your careers as well, or you already have. But one that particularly comes to mind was the entire pricing structure, where our client said, "Oh, look, we're just going to be paid this lump sum for this work," and then we read through the contract, and it was all like hourly rates up to some sort of cap. So even at a even at a basic level, the whole way that they were going to be paid and the whole point of having this deal in the first place was completely different to what our commercial team thought. And even if we didn't have that information, we didn't know it was meant to be lump sum, we would still flag the way that the pricing worked in the contract. We wouldn't just assume they had a negotiator and it's all fine. We're saying, look, is this how you want this contract to be priced? Because that's how you're going to make your money, and we just like you to confirm that. So yeah, never assume is a really good point, Daniel. Um, and I think, if we kind of nailed the first read through and that kind of all makes sense to you guys and it's clear enough to follow, let's go to the second read through, which, you've got your handy list of notes or comments in the document. You've got a bit of an idea of what the contract all means. You can go back through and refer to those notes and check things off and actually flesh it out for those next few steps, right, of the contract review layers. So number 3, linking it to the practical implications, and number 4, evaluating it according to market standards. I think as the initial step, you'd read through that list that you've got and try to trim out the non-material issues. Like, okay, maybe don't delete them entirely, but you can kind of prioritize them by saying, look, these look like the key issues to me, and these look like lesser issues that the client might want to be aware of, but probably won't be deal breaking and might not have the same impact. And then work through those issues, step by step, by trying to link it to those practical implications. Try to evaluate it according to the market standards. Identify the areas that you need input from the client, and then also just flag for them the areas that you'll need to do deep dives in if they are also critical issues as well, right? So this second review, you're essentially turning your notes from your first review into client-facing narratives. It's not just enough to have, hey, this looks like a big risk, which is what I would write in my brief notes, saying, look, clause X says this. This seems to be different to what you expect in this sort of project or in the market standard. We'd usually expect to see something more like this, and we suggest that you raise a departure that negotiates it more in line with this, right? Or you might have client facing narratives again saying, hey, is this okay? Is this a risk that you're willing to take? Can you price it? Can you manage it? Adding commentary on those practical effects, on what those market positions are, and again, highlighting the areas that you need their input on. So I think on the next slide, Daniel, we might have an example of what this would look like if you turned a note into this sort of narrative. not cooperating?
Nope, do you see it?
I do not see it.
Oh, it's switched over. Hold on. There we go. Is it back on?
Yeah, it's close enough.
There we go.
Yeah, so this is just, something that I wrote in 10 minutes before this. Something, if I was reviewing a contract for Russell Westbrook's whatever employment contract, I'd say, look, the contract value is this presents an issue for your team because his inefficiency from 3-point range and turnover rate. For comparison, this other guy, his contract is this much. It's also above average, but has a higher impact on his team's winning percentage. And then I might have a note there for the commercial team saying, hey, can you please confirm whether this should be how we evaluate whether it's a good risk or not, right? So again, completely pulled off the top of my head based on bitterness, personal bitterness, but I think it's kind of good to get that sort of frame of reference saying, look, this is something that we have a narrative on that we can provide a recommendation on. And it's not unusual for you to have another client call to actually work through these issues, especially the highlighted commercial issues, to really refine your contract review and actually deliver the final product. So you can also view it as, look, there's an opportunity to have a conversation with the client based on this. So don't be afraid to actually just raise those queries, or, because I think pretty much all of us are junior lawyers, raising it for our supervisors, right? Look, I've thought about this issue. This is what I think the solution is. I might be wrong, but this is the starting point, and I've actually put thought into this. So could you please let me know if this is actually right? And I think if you're taking that sort of approach and trying to find an answer, even if it's wrong, it's a way better way to get into the feedback cycle and actually learn from this sort of exercise than if you just say, look, I've flagged a risk. This looks like a risk. Here you go. I don't know what to do with it, so I'm not going to try. It's just harder to provide feedback to you based on that, especially on the technical side, because I guarantee the first piece of feedback you get from that sort of work is, oh, you need to provide a recommendation, and I can't give you more specific feedback unless you actually give it a go. So yeah, that's what I would say a second read through should produce, a whole sort of running list of this sort of stuff where you can actually talk to the client and have a recommendation ready to go from your back pocket, or other questions that they need to confirm, right? So I think, I say second read through, but it could be second, third, however complex your contract is, just beyond the first read through, these are the things that you try to refine from. So then I'd move on to finalizing the contract review, which is step 5 of what a good contract review does, which is, again, providing the recommendation. So set out what you recommend should be done in relation to the material risks. So for example, these could be things like negotiating a different position, pricing the risk, checking whether you have insurance coverage for it, or, in extreme cases, look, you've tried negotiating and they're not accepting it, and this is such a key risk that it's just not worth entering into this sort of contract for, because you're taking too much liability for what you're pricing and you can't increase the price, so it's just not worth it. This could be a recommendation to walk away. Again, very extreme, but as part of our role, that could be something that pops up. Like I said, if you had a call with the client at any stage during this as well, you'd be incorporating their input. So you could be saying, like, from this call, you told us that this, so on this basis, our recommendation is this. And as part of this as well, you could set through material assumptions, and hopefully no one's just squinting and trying to read this as I'm talking. We'll get to it. We'll get to it soon. But really trying to set out the material assumptions as well, because like I said, there could be documents, for example, commercial schedules that the client is responsible for reviewing that are excluded from your contract review. It's not really ask covering. It's just saying, look, we've only looked at this set of documents, so if you want us to look at anything else, just let us know and we'll look at it. And if there's any documents that you actually haven't been provided, which in my line of work, it's not unusual for, if I'm bidding for a project, for the person trying to run the project to have not finalized all the documents at that stage yet. So there's gaps in the contract review that will need to be filled later. And also, if there are any commercial terms that are still being negotiated, still being finalized, those could be assumptions as well, saying, hey, we know that there's this whole area or this whole regime of pricing that you're still talking about. And for the purposes of this review at this time, we haven't looked at that. But if you want us to refresh it, please let us know. And again, prioritizing the key issues over the lesser issues, hopefully with a bit more of the input from the client and with your supervisor being able to rank it. So it'll look like, hey, these are the key issues that we'd like you to, consider negotiating or pricing, 1 to 10. By the way, there's, 11 to 20 that you might want to consider that might be material to your business. So now we'll turn on to the slide, and I don't want to read this out to you, but, look, it's saying, here's the project. This is a red flag review for these documents in relation to you, the client. For this project, you've asked us to do a red flag review in respect of these documents, right? And a bit of context for the project if you can. Then if we just look at the first line item, limitation of liability, exclusion of consequential loss. Look, I really don't want to read through this because I think that's just going to bore everyone. But again, it's kind of running through that whole system of, like, this is what's in the contract. This might be what's missing. This might be what's has a practical impact on you. This might be what is not market standard. And this is our recommendation. So, the last few lines, we recommend that the carve out from the cap on liability for this loss should be amended for blah. So if you run through that sort of thing for whatever line of work you're in, you're going to be producing a pretty good contract review that is just technically sound, but more importantly, can be used by the business to actually do things with, right? They're not just wondering, well, yes, that's a risk, but is it a big risk? Is it a small risk? Does it have a practical impact, or are the lawyers just kind of fiddling with words for the sake of it? Those are all the things that make up a good contract review, and again, has a role in the modern businesses and the people that we actually work with. So I think on that basis, that's kind of my big spiel. Daniel, did you have anything else you want to chip in?
No, I think the only thing I would add on is when you were talking about the second read through and evaluating according to market standards. Often what I would appreciate seeing in these kind of reports is where we're dealing with, say, like company A, and you have experience contracting against company A, providing your input to say, okay, well, usually they allow this provision and usually they don't allow this provision. For me, that's actually very valuable, especially if the scope of my contract review here is for me to negotiate further. So I think it really depends on what you're doing this contract review for, but you can find little kind of value adds here and there.
Yeah, awesome. So I think that's generally all the content we have. We do have a bit of time for questioning, but just before we dive into that, just a little bit more about, Daniel and myself and how you can actually reach us and what to reach us for. So we're both active on LinkedIn. We both write on there regularly. So for me, if you want more of the how-to guides and practical resources as a junior lawyer, you can, reach out to me there, but also on my website, practicinglaw.com.au. And I also do graduate and junior lawyer training for law firms. So if you do have a contact or you're interested in this sort of stuff, like the really practical nitty-gritty step-by-step stuff, then feel free to reach out to me as well. I'd love that. Daniel, for you?
Yeah, and on the other side, I do more kind of one-on-one career coaching, career strategy, law school, and even master's applications. I help review as well because I also did my master's. So that's the kind of bits I do, and I regularly post on basically motivational posts, but also career guidance as well from my experience.